Hello, Max Travis here, and we are talking about commercial litigation. Commercial litigation concerns itself with the resolution of disputes between business entities within the American legal system. Let's say you find yourself in a dispute that cannot be solved through the normal course of business. Let's make this dispute as simple as possible. You contracted with Company X, you performed work for Company X, and you weren't paid by Company X. Not only that, Company X has made it clear to you that it won't ever pay you for your work. Now what? Well, one thing you can do is retain an attorney and avail yourself of the courts for redress. What would be the point of this? Well, for one thing, the American legal system is involuntary. That means it doesn't matter whether or not Company X wants to have the dispute decided by a court. As soon as your attorney commences litigation and serves legal papers on Company X, they're required to show up and defend themselves. What do I mean by required? Well, what happens if they don't show up? Here you are, you've retained an attorney, you're paying litigation expenses, and Company X doesn't show up. Now what? Well, your attorney would likely move for a default judgment. Depending on your claims, you will have to prove that he provided the proper notice to Company X, and then prove to the court that you are owed the money you say you were owed. If Company X doesn't still show up, then the court could enter a judgment against Company X. A judgment is a piece of paper filed with the court clerk which states that Company X owes you money. Okay, now what? Well, let's say Company X doesn't have a sudden change of heart and fork over the money they owe you. The next step is to take this judgment and to collect on it. Do you know where Company X keeps their money? If it's in the bank, you can send a legal notice to their bank to restrain Company X's funds. If Company X has a real property, you can seek to foreclose upon that real property. Well, who actually goes and gets Company X's money for you? In New York City, it is usually the New York City Sheriff. But importantly, the New York City Sheriff does not actually find Company X's money. It only collects it. You have to direct the sheriff to where Company X keeps its money. This is not always easy, and is something to keep in mind when you are considering litigation. You are suing these people that owe you money, but do they have money? At the end of the rainbow, is there an easily accessible pot of gold which makes litigation worth it? But what if you do find assets and you inform the New York City Sheriff of where they are? The sheriff will send a notice of execution to the entity holding the assets and demand that they pay it. If it's a bank, the bank will very likely fork over the money to the sheriff, will then submit it to you. But let's have some fun. Let's say Company X keeps all of its money in a cash in a treasure chest buried in the CEO's backyard. Company X receives a notice of execution from the sheriff demanding that it pay the money to it. And then Company X refuses to do so. Now what? I actually recently asked this question to a deputy in the New York City Sheriff's Office. What if Company X simply ignores the sheriff's notice of execution? What I was told is that sheriff gets something called a break-in order from the court, which allows the sheriff to just come into the property of Company X, dig up the treasure chest, and take it away. I then asked what happens if the CEO of Company X gets in the New York City Sheriff's way, like violently. There was a pause on the other end of the telephone, and then they said, well, I suppose we would call the police. Which all goes back to my original point. The American legal system is involuntary. Almost no litigation, if any, actually ends up with the New York Police Department dragging someone off to jail. But it could happen. That is the end of the line. A citizen litigator will always keep two goals in mind. Is it possible to resolve this dispute in a voluntary fashion to save the client the expense of prolonged litigation? And two, what do we do? How do we prepare to force the situation if a voluntary solution is not possible? Both avenues need to be pursued because at the end of the day, what makes parties voluntarily resolve the disputes is the reality that the American legal system will act to resolve the dispute for them, by force. I look forward to working with you in this regard.